Hello, ladies and gentlemen. James here. Hope you're doing well. I want to show you something right quick. Um, Hope it gives me the. I'm on a different software. My camera, laptop camera, acted up. But here's some latest video on citizenship. Hopefully, here to play. Come on. I don't know if a lot of people know about this.
Welcome to Legal Lens USA. Following Donald Trump's election win in November 2024, significant changes to the United States immigration system were anticipated. Fast forward to late June 2025, the U.S. is now navigating a new phase marked by reformed citizenship laws. For many generations, being born within U.S. borders automatically conferred American citizenship, irrespective of the parent's status. The method of their arrival also held no bearing. However, in June 2025, after years of debate, litigation, and political promises, the Supreme Court facilitated President Trump's executive order to significantly alter birthright citizenship, an adjustment with profound implications for families, communities, and the national identity. In this video, we'll explore how these changes unfolded, what the executive order entails, who it impacts, and why this might be one of the most significant changes to U.S. immigration and constitutional law in recent history. If you're enjoying the video, kindly click the bell icon, subscribe, and like the content for updates delivered directly to your phone. Now, let's dive in. Upon his return to the White House in January 2025, Trump promptly resurrected a key promise from previous campaigns, ending automatic citizenship for children born in the U.S. to non-citizen and non-permanent resident parents. On his first day back, Trump signed the executive order titled, Protecting the Meaning and Value of American Citizenship. This order aimed to reinterpret the 14th Amendment, which for over 150 years had granted citizenship to almost all children born on U.S. soil, independent of their parents' immigration status. Trump's decision was not unprecedented. He had raised this idea during his earlier term, but this executive order was sweeping and immediate. It stated that, effective 30 days from January 20th, 2025, only children with at least one parent who is a U.S. citizen or lawful permanent resident would automatically receive citizenship at birth. The executive order, taking effect on February 19, 2025, introduced a new reality for numerous families across America. From that moment forward, a child's birthplace in the U.S. would not guarantee citizenship. Only those with at least one parent who is a U.S. citizen or lawful permanent resident would be recognized as citizens at birth. This order also explicitly covered children of non-immigrant visa holders, including students, temporary workers, and tourists. Regardless of lawful presence, federal agencies were directed to cease issuing citizenship documents, such as passports and social security cards, to children who didn't meet the new requirements. Hospitals and state agencies must now verify parental status at birth, leading to considerable administrative confusion and worry for families. The order faced fierce legal challenges almost immediately. Civil rights organizations and a coalition of states launched lawsuits, contending that the order was unconstitutional and would create chaos for families and government bodies alike. In several states, federal judges swiftly issued nationwide injunctions to temporarily halt the order's enforcement. However, on June 27, 2025, the Supreme Court delivered a crucial ruling. The court refrained from directly addressing the executive order's constitutionality, but significantly restricted lower courts' authority to issue nationwide injunctions, allowing Trump's order to take effect across most states while legal challenges proceeded.
I want to show you this one on marriage right quick. And the reason why, because a lot of people think that marriage is not what you think it is going to be this time like it used to.
Fake marriages now mean real prison time. In 2025, just one mistake in your green card marriage case can get you deported, arrested, or banned for life. love is real. Let's talk about what's really happening this year with marriage-based green cards and why the stakes have never been higher. Marriage fraud in 2025. What's really at risk? In 2025, the U.S. government is taking a hardline stance against marriage fraud. With increased collaboration between USCIS, ICE, and the Department of Justice, even small signs of a non-genuine relationship can now lead to serious consequences, up to 5 years in federal prison, removal from the country, and permanent bans from re-entering the U.S. Even green card holders aren't safe if fraud is discovered later. And in this enforcement-heavy climate, the definition of fraud has expanded. What counts as marriage fraud in 2025? Marriage fraud isn't just about faking paperwork or staging a ceremony. It's about intent. If your relationship exists solely to obtain immigration status, even if you followed legal procedures, it's considered a federal crime. Some common patterns flagged in 2025 include paying a U.S. citizen to marry for papers, friends or family marrying as a favor without any plan to live together, immigrants pretending to be in love only to disappear after receiving status, mutually agreed fake marriages where both parties know the deal. What these all have in common is a lack of genuine connection, and those signs are easier than ever for USCIS to detect. What USCIS looks for in 2025, it's no longer just about showing a marriage certificate. USCIS now investigates every marriage-based case using joint leases or mortgages, bank accounts and shared finances, photos from vacations, holidays, and daily life, social media history and digital footprints, matching addresses and consistent stories. Officers are trained to detect inconsistencies. If your Facebook says single or your Instagram shows solo trips, it could trigger a deeper fraud investigation. Marriage interviews, now more intense than ever. The marriage interview is no longer a formality, it's an interrogation.
You know, the thing about it is, before I'm going to interrupt here, a lot of immigrants try to get the American counterpart to do it like this, but they go about it a different style this way. It's not that you just can't take a picture no more like, you know, they used to and show that they showed that officer or whatever. And a lot of certain people from different places in Africa, like Nigeria and different other countries, would try to get with somebody's here and do something like that. You know, there's some of them that would, not everybody do it, but some people do it. But here's another thing I want to show you, too. I just want to show you that quick. See, the rules are changing in America.
Breaking, denaturalization and IRS, what every naturalized citizen must know. Denaturalization, stripping away U.S. citizenship, is no longer a rare, extreme action. It has now become one of the Justice Department's top 5 civil enforcement priorities. The memo announcing these priorities was issued on June 11th. It made one thing very clear: this government intends to actively seek out cases where citizenship can be revoked. Historically, denaturalization was reserved for war criminals, spies, or terrorists. Today, the net is much wider. It includes cases linked to financial crimes, fraud, and even tax violations. This isn't speculation. It's written into official enforcement priorities. And it's why experts are warning that millions of naturalized citizens should be paying close attention to what's happening right now. Why civil denaturalization is so dangerous. Under civil denaturalization, there is no statute of limitations. That means the government can go after your citizenship no matter how many years have passed since you naturalized. If they discover evidence that you obtained citizenship illegally, or misrepresented a key fact during your naturalization process, time does not protect you. Even something that happened 10 or 15 years before you became a citizen could still be used against you today. That's why immigration lawyers are calling this a game changer. 2 main triggers for losing citizenship. The government generally relies on 2 broad reasons to strip citizenship. The first is illegal procurement, meaning you should never have been granted citizenship in the first place because you were ineligible. The second is misrepresentation or concealment of a material fact during the naturalization process. This includes lying, omitting key details, or giving an answer that the government later proves to be false. The most
most dangerous part? Even mistakes, not just deliberate lies, can be used if they decide it counts as a material misrepresentation. How the IRS became involved. The Justice Department memo added something that raised serious alarms. It explicitly included tax violations as a potential trigger for denaturalization. That means if you underreported your income, claimed deductions incorrectly, or made errors in your tax filings before you became a citizen, and failed to disclose them, you could be at risk. The memo also listed Medicare fraud, Paycheck Protection Program fraud, and other financial crimes, even those against private entities. This is a radical expansion of what can now be considered grounds for citizenship revocation. The hidden danger on the N-400 form. If you've gone through naturalization, you know about the N-400 application form. This is where a major trap exists. Part 9, Question 15a asks, have you ever committed, agreed to commit, helped commit, or tried to commit a crime or offense for which you were not arrested? If you underreported income to the IRS before citizenship, that's considered a crime, even if you were never arrested or charged. If you answered no to that question, and the government later gets IRS data showing the underreporting, that becomes their legal foundation for denaturalization. It's that simple, and that dangerous. DHS wants direct IRS access. The Department of Homeland Security is now actively trying to tap into IRS records to identify cases. They've already submitted a request for 40,000 specific records, hoping to match personal and financial data with immigration files. The IRS was only able to match less than 3%, but that's not stopping DHS. The demand for IRS data is growing, because it's one of the fastest ways to verify past financial activity that could be tied to misrepresentation during naturalization. Internal battles over privacy. The IRS has strict privacy rules. Sharing too much data with DHS could violate federal law. The former IRS commissioner reportedly refused to go beyond what the law allowed. Shortly after, he was removed and reassigned as U.S. ambassador to Iceland. This move has fueled speculation that there's intense pressure inside the government to expand IRS-DHS data sharing, and that resistance to this push comes at a career cost. How far back can they go? The IRS keeps different records for different lengths of time. In some cases, it's 3 years. For more serious matters, it's 5 or 10 years. If fraud is involved, there may be no limit on how long they can go back. That means financial actions you took long before applying for citizenship could still be examined today, especially if they can be matched with information from your immigration file. Who they're likely to target first. Experts believe investigators will start with the most recent records. Modern IRS records are more complete and easier to cross-check with immigration data. The technology for matching employment history, tax filings, and immigration answers is much stronger today than a decade ago. By focusing on recent cases, they can build evidence faster and move toward court action without sifting through decades of incomplete data. The green card process link. Here's where it connects back to your earlier immigration history. During the green card process, the government asks for your last 5 years of employment history. They don't always verify if you paid taxes during that time. But now, with IRS access, they could. If your immigration forms show you were working but the IRS has no record of tax payments, that's a red flag. That gap could later be used against you in a denaturalization case, even if you've been a citizen for years. The high-risk scenario. Imagine this, you had a job before citizenship where you earned cash income but never reported it. Years later, DHS accesses IRS data and sees no taxes were filed for that.
No matter if it's birthright, citizenship, and no matter something like this. Either way you do, they going over every record. They going over the medical record. They go to your kid's school's record. They can go ahead and check your employment. And if any employer employs you, they can be fined, heavy fine, and everything. So this is just a warning. This video is just set up to be a warning. Things ain't like they used to be. And I think people who come to this country need to understand the laws. It's not like it used to be. They're updated now. So anybody come from any part of the world think that they're going to get over and get under, they're going to get popped. Simple as that. Their system's upgraded. So alright then guys, I hope you this really informative. Take care.